Hello, today we'll look at constitutional law and we'll focus on equal protection and due process. So for these objectives, we're going to look at how the United States Constitution and constitutional law applies to private and public sport entities. We'll look at the freedom of speech and freedom of religion protections provided for the First Amendment. We'll look at the First Amendment a little bit as it regulates religious prayers and activities, but really focus on substantive and procedural due process, what they are, and how the requirements apply to all sorts of different types of organizations, as well as look at the equal protection clause and see how it affects different types of plans. So the application of the constitutional law involves the application of federal and state and local governments and whether their actions violate one or more terms of the U.S. Constitution. The U.S. Constitution is a document that governs our government. It says what our government can and cannot do, and it guarantees our rights as citizens. So the constitutional law involves state and local governments and whether their actions violate the U.S. Constitution. Purely private entities generally are not subject to constitutional claims. So if you have a private organization and that private organization isn't just, not public, it's very limited in what the private definition is, and we'll look at it in the future. First place that we always start with constitutional claims in a constitutional discussion is state action. Is there state action? Is the state or local government acting in our situation? State action are those who act in furtherance of their position as employees of governmental agencies. In other words, public school teachers, police officers, IRS, DMV, state-run universities, public schools are considered state actors because they are representatives of the state. In Indiana High School versus Durham, we look at what a state actor is and what they're not allowed to do in terms of the High School Athletic Association. Are high school athletic associations, are they considered state actors? Can they limit and make different rules that create eligibility issues for students? For the most part, generally, high school athletic associations are considered a state actor. When are private entities state actors? Private parties can become state actors through their actions. So if you're not a governmental organization that's set up through the government, if you're a private actor, under two different theories, you can be considered a state actor. One is this nexus or entanglement theory. This examines whether the state's involvement or entanglement with a private actor's conduct is sufficient to transform the private conduct into state action and thus subject to constitutional review. In other words, it will look at, in the Tarkanian case and Brentwood case, actually show both these ideas of private actors becoming state actors. Certainly the Brentwood case, is the Tennessee High School Athletic Association on their own, it appeared that they would be a private actor. They're not set up or they're not a governmental agency. However, as the person presenting this case will show us, there are a lot of entanglements. There's a nexus. It was predominantly housed by public school athletic directors. The people who worked there were a part of the state retirement fund. You got, it was housed in a state facility. So if there's a lot of entanglement between the state and the organization, that private actor may be considered a state actor for constitutional review. The second is a public function theory. And a court can find state action if that private party undertakes functions or assumes powers that the government ordinarily performs or exercises. That's not that common in sport and recreation. However, we can see it in a couple of different areas. The idea of this theory may be seen very easily. If the government is not allowed to open your door whenever they wanted and go through your things for a warrantless search, it doesn't make any sense for the police department to say, hey, I'm going to hire somebody to do that for me. If it's illegal for the police to do it, it's going to be illegal for somebody to do it in their place when it's something that they normally do. So we look at the nexus or entanglement theory, which is very important because a lot of what we're looking at here in terms of state actor comes through that idea. And the other one is public function theory, where a private actor is doing something very similar to what the state would do. Generally, that high school athletic associations are state actors. We'll look at this in the Brentwood Academy. The Ohio High School Athletic Association is an exception. Most of these are because of either the nexus or entanglement theory, or they're specifically created through the government to run that area, so they're considered a state actor. The NCAA is not a state actor, as we're going to look at NCAA versus Tarkanian, and it's interesting because when you compare and contrast a high school athletic association and the NCAA, at first blush, they do very similar things. They create rules, they run championships, they work in the best interests of the student athletes. But the NCAA is not a state actor. Professional sport teams and leagues and teams are not state actors either. They're private organizations. So we'll look at Brentwood. We'll compare and contrast that to Tarkanian. We can look at Stark versus Seattle, when this is a case that deals with entering into a stadium and going through a weapons check and getting pat down. Can the Seattle Seahawks do that in terms of violating somebody's right? Are they a state actor? Is the stadium that they are a part of and they run their games through, is that considered a state actor? The 14th Amendment of the Constitution really highlights the two main sections of this chapter that we're looking at. One is the Equal Protection Clause, saying that the law will be applied in equal and non-discriminatory manner to different people. And the other is a Due Process Clause, along with the Fifth Amendment, that a person cannot be deprived of life, liberty, or property without fair process or hearing. Again, these are constitutional questions. This has to be done if you're a state actor. If you're not a state actor, these may not apply to you. The NCAA is not a state actor, so they, in theory, do not have to follow in line with equal protection or due process. However, it's a recommendation. The NCAA certainly has gone this direction of providing at least some equal protection, some due process, so that these constitutional claims won't be brought up in court and a court will overrule and say that you need to do these. If we're looking at, three different standards of review for equal protection. The first is known as strict scrutiny. For strict scrutiny, it's going to be very limited, but that means that the law is going to be strictly scrutinized in how it's being applied. Second one is intermediate scrutiny, and the third one, and most common in our sport and recreation area, is this rational basis review. So we'll look at each one in turn. Strict scrutiny is triggered when a state deprives a person of his or her fundamental rights, which would be freedom of speech, the right to assemble peaceably, the right to privacy, right to vote, or right to privacy. Here, the government needs to show that the challenged law or practice or rule is necessary to achieve a compelling governmental interest. And it's very important to write down and take notes of this language. It's necessary to achieve a compelling state interest. It is necessary. This is the only way to achieve it, a compelling governmental interest. When we think of compelling governmental interest, there aren't that many of them. State security, maybe something else, but it's very limited. So when we look at this type of rule under strict scrutiny, the vast majority cannot survive. If you think of strict scrutiny as a big brick wall going up to a ceiling, there may be 6 inches at the top that you can climb over. This wall is going to stop most state action. It also applies when there is race, national origin, or religion as a protected class is being questioned. So we'll look at Fusado versus Washington Interscholastic Athletic Association. Which level of scrutiny can Fusaro bring into court with this eligibility question? If it's strict scrutinized, then with her claim, it's not going to be able to be upheld. It has these suspect classes like race, religion, national origin, and alienage. The suspect class is something that's specifically protected by the Constitution. Intermediate scrutiny is the second level. If the wall goes all the way up to the top for strict scrutiny, this goes maybe halfway. The rule of practice is substantially related to achieving an important governmental interest. Compare and contrast that to that strict scrutiny where the rule, practice, or law is necessary to achieve a compelling governmental interest. You see this one is dramatically lower. Has to be substantially related to achieve an important governmental interest. So we look at here, a lot of this uses in gender and contact sports, scheduling season, Title IX issues. Some sexual orientation questions are beginning to be seen under intermediate scrutiny, but it has to be substantially related to achieve an important governmental interest. So when we look at Rotman versus PA Interscholastic, under an intermediate scrutiny, we see that a lot of this will be challenged and struck down, but as long as it's substantially related, it doesn't have to be the only way. A court can look at this in terms of maybe the best way or one of the best ways to an important governmental interest. It doesn't have to be compelling. It has to be important, though. We'll look at Lutke versus Kuhn, and this is the women in the locker room that the video is set up to describe. And certainly going through this again with a very recent case of television broadcasters doing after game interviews and nude players are walking around the background. There's conflicting interests with all these cases. And certainly in the 1970s, this idea of a woman going into the locker room was certainly something that was banned across the board. And this is a challenge that we see through the New York Yankees. Interesting also, when we look at these claims, first step, is there state action? Is there a state actor that has to guarantee these constitutional rights? We'll also look at Hoover versus Meiklejohn. This is considered a quasi-suspect class, that originally there was just the rational basis and the strict scrutiny, and then courts used the sliding scale, this idea of a group in between to use this secondary level, this intermediate scrutiny to apply to gender. And as I said, now there's some sexual aspects to it coming into play. The most common and the lowest level is this rational basis review. Again, the wall all the way at the top for strict scrutiny, halfway up for the intermediate. Rational basis, maybe a foot off the ground. It's going to block some, but for the most part, we're going to be able to get over this. And by the most part, we're going to get over it, mean the rule is going to be accepted. Here, the state needs to show that it is the challenged rule of practice is reasonably related to achieving a legitimate state interest. Strict scrutiny was necessary to achieve a compelling state interest. Here is reasonably related to achieve a legitimate state interest. And this is for everyone that's not in that suspect or quasi-suspect area. So a legitimate state interest, eligibility, emphasizing education over athletics, residency, safety, and has to be reasonably related. A court can disagree that this is the best way or the way it should be done. Is this a way to accomplish it? And is it legitimate? Then a court is going to accept it as long as it's rational. So when we look at this idea at the three different areas, suspect, the key words necessary, compelling, quasi-suspect, substantially related, important, all others for this rational basis, reasonably related and legitimate. Under due process, it's this idea that we're allowed to have legal proceedings to protect and enforce our rights. It's guaranteed in the U.S. and state constitutions. It doesn't mean that we are entitled to a court of law at all times. It does require us to go through some sort of process where we are notified of what the rule is, and we're provided some sort of hearing in order to address any claims against us. Due process is developed to prevent arbitrary, capricious, and unreasonable decisions. This idea of a precedent, this idea of stare decisis, this idea that we are going to apply the law fairly and impartially to every single person. It's how we treat others, how we are going to be presented with this different types of claims. Due process is triggered when the government deprives, again, a state actor deprives someone of life, liberty, or property interest. A life interest is your life or your freedom. Liberty, privileges recognized as essential to the orderly pursuit of happiness by free man, or property interests, all valuable interests that can be possessed outside of oneself, which have an exchangeable value or which an individual wealth or estate. Athletic scholarships are considered property if we're in the middle of the scholarship time. In other words, if you are under scholarship and you have the contract and you're exchanging your athletic prowess in order for your free room and board, the government, a public school, can't take that away from you without a hearing. You have to have some sort of violation. However, a future pro career is not considered property because there's no guarantee of it. There's no exchangeable value of a future pro career because it doesn't exist yet. Tiffany versus the Arizona Interscholastic Athletic Association brings this case into light with this idea of due process. We'll look at two types of due process, substantive and procedural. Substantive due process looks at the rules and regulations themselves. They need to be fair and reasonable to protect people from arbitrary and capricious actions. This is the rational basis. It's not that big of a hurdle for a government to show a rational basis for the rules, that it's reasonably related to a legitimate state interest. Generally, courts will not interfere with the internal affairs of voluntary associations. That as long as it's a voluntary association, a court will look at the rules and see, are they unconstitutional? If not, the voluntary association, even if it's a state actor like a high school athletic association, because you can change the rules. If you don't like the rules, you can change them. You can change the punishments. You could leave that organization and create a new one if you want. So there's no guarantee and there's no person forcing you to be a part of this. You can leave it at any point and change the rules, so courts will not interfere with that, allowing the organization to run itself, as long as it doesn't violate its own rules or is unconstitutional or fraud. As long as it's being applied correctly, then we're okay. And that's the idea of this procedural due process. How is it being enforced? We're looking for fair treatment. Is this rule being enforced in the same manner every single time? The decision-making process followed to determine whether the rule or regulation has been violated and what sanctions. So this is applying it. Minimum due process we're looking at, is there notice and hearing? Do you know what rule it was? Do you know what you violated? Is there a potential for an opportunity for the accused to comment on it? Maximum due process, we look at all these other aspects of written notice, written statements, going directly against your adversarial, a tape recording of procedures, right of appeal. Many of these due process requirements are involved at different levels in sport and recreation, and we'll certainly look at procedural due process through a number of our cases. So we looked at top line here of state action, of constitutional law. Is there state action first? We looked at due process, what different types of due process there is, substantive and procedural. And we also looked at the equal protection clause of the 14th Amendment, where we're looking to apply the law, although we don't apply it equally, perhaps. There are three different types of scrutiny that a court will undergo challenging this law. Strict scrutiny, if it's a part of the suspect class, if it takes away one of our fundamental rights, or if it deals with race, religion, alienage, former foreign person domicile. Is it a part of the quasi-suspect, that intermediate scrutiny, or is it a rational basis? So we looked at a few different aspects today, and certainly look at the cases as they flesh these different concepts out. Thanks.